I'm Matt Bishar with NAREIT.com here in Phoenix, Arizona for REITWise 2015, NAREIT's Law, Accounting, and Finance Conference. I'm joined by Shirley Goza, General Counsel with QTS Realty Trust. Shirley, thanks so much for joining us.
Thanks for having me.
Now, can you start by talking a bit about the role of REIT General Counsel as in-house gatekeeper and how that's evolved over the years?
I think there's always been the expectation that both in-house and outside counsel be business savvy. Early in my career, a partner explained to me the importance of the lawyer understanding the business and looking for the solution that serves the client. The legal solution, of course, rather than just saying no and explaining why it's not possible to do whatever the client needs to do. There's also the balance of risk against running a profitable business, the economic consideration. And I think that expectation has continued to grow. I think the thing that's changed most in-house is the integration of the lawyer into the business process. So most general counsel, I think, serve on the executive committee and are part of the business-making decision. So the lines get blurred, and the decisions then have to be made carefully by the lawyer to allow the client to make the business decision, the lawyer to provide the appropriate options with the right direction, and insist that the business live with the business decision.
And what stands as the biggest compliance challenge that those in a position similar to yours face?
Well, I think the toughest part is the balance between looking at your ISS or Glass Lewis or Green Street score and still making sound business decisions about what's right for your business and what is appropriate governance for your business. So important not to let the tail wag the dog and to still focus on the business and governance that is right for your business.
And lastly, what impact do you think the Dodd-Frank clawback provision could have on corporate governance?
Well, we haven't seen the rules from Dodd-Frank yet. So if the reports are accurate, most businesses have, adopted policies already. So there's some anticipation of what will be expected, but ISS takes into account whether you have a clawback policy. So most companies, I think, are taking a stab at it. I expect that most companies like ours decided to make that clawback policy as tight as possible. So only allow it to apply to the CEO and the CFO, and only, don't expand it in any way. That's at least the focus that we've taken. If we see rules that require something broader than that, then there, of course, will be, modification of the policies. I think there's going to be pressure, especially if the clawback rules must apply to a broader group of executives. I think we're going to get some pushback from executives who will have to take on additional risk without additional compensation. So I expect that there will be some pushback in that regard.
Great. Shirley, thank you so much for joining us.
Thank you for having me.
Great. For more on this and other REIT news and analysis, be sure to visit REIT.com.